All right. So this is the matter of Chad Murphy and Artisha White, Utica National Insurance and Georgia Farm Bureau Mutual Insurance. Is that right?
Yes, Your Honor.
All right. Do you this is the see Georgia Farm Bureau's motion to dismiss.
Yes, Your Honor.
Do you wish to have this matter taken down, Mr. Broder?
Yes, Your Honor.
And do the other parties wish to join in? Well, who's here?
Mr.
Uh,
Hudson is here on behalf of the plaintiff,
okay. And
but
so,
I wasn't sure if we could hear him or not, Your Honor.
Mr. Hudson, can you say something else for me? No, we can't hear you. Miss, maybe you need to log out and log back in. We'll hold for you. Miss Maynard, the court reporter. Miss Maynard, can you put into the Zoom information about how to, is it already in there? About how to receive your payment.
I will,
Okay.
Your Honor.
I see there's also someone else logged on named Caitlin Long or Luong.
Yeah. Good morning. I'm UM.
Is that Utica?
Yes.
Okay. And is there anyone here on behalf of the defendant, Artisha White? Okay. All right, Mr. Hudson, can we hear you now? Did you say something? Yeah, can't hear you. So there you go. You came, it came in for a second, I thought.
Nobody's got me?
Gotcha.
You got me?
Yes.
All right.
All right. You pushed the right button. All right. Did you wish to participate and take down, Mr. Hudson?
Yes, ma'am, I do. And I apologize. This is actually my first Zoom hearing, strangely enough. So if
Okay.
anything goes wrong, just bear with me.
No worries. My court reporter, Ms. Maynard, indicated she was going to put in the chat how to get the payment to her for the takedown. So, Ms. Maynard, you let me know when you are ready.
Judge, just so I don't slow things down, go ahead and proceed. I'll get that taken care of.
All right. This is the matter of Chad F. Murphy versus Artisha White, Utica National Insurance, and Georgia Farm Bureau Mutual Insurance. Case number 2025 CV 06187. This is the defendant, Georgia Farm Bureau Mutual's motion to dismiss plaintiff's amended complaint. Mr. Carl Broder is present on behalf of Georgia Farm Bureau. Mr. Shane Hudson is present on behalf of the plaintiff. And I believe we do have an attorney, Caitlin Luong, present for Utica National Insurance. Are you ready to proceed with your motion, Mr. Broder?
Yes, Your Honor.
All right. And Mr. Hudson, you're ready.
Yes, ma'am.
All right, Mr. Broder, you may proceed.
Good morning, Your Honor. My name is Carl Broder. I'm here on behalf of Georgia Farm Bureau. This is a somewhat unusual case, Your Honor, in that the claims that are being alleged against defendant White are not from her actually striking the plaintiff, Chad Murphy, but from an impact that happened to Mr. Murphy's nephew, who was also a co-employee on a construction site on, I believe, 1941 in Clayton County. As alleged, there was no impact between Miss White, who appears to have been negligent or is alleged to have been negligent, and Mr. Chad Murphy, but instead he received some sort of injury after stepping down, tripping or falling off a piece of construction equipment. Plaintiff has filed an amended complaint. There's been a second amendment to the complaint that might affect one of the arguments I'll address in a moment. But there are two claims that have been raised. One is the claim of negligence against the defendant, Ms. White, and there's also an alleged breach of contract against Georgia Farm Bureau as the UIM carrier. With regard to that, I would note at the outset two particular paragraphs in the First Amendment complaint for the court's attention. The first is paragraph 35, which makes a reference to seeking recovery of attorney's fees and expenses against Georgia Farm Bureau, and paragraph 39 of the First Amendment to the complaint, which notes that the denial of payment to the plaintiff was motivated by bad faith. We were moving to dismiss the First Amendment complaint on two grounds. First is that the complaint fails to allege facts supporting that the uninsured motorist, Ms. White, was the proximate cause of his injuries. The second is that Georgia Farm Bureau is not subject to a direct claim for breach of contract or bad faith in this current action. Regarding the proximate cause issue, we do not believe there have been facts sufficiently alleged to establish that Ms. White was a proximate cause of the injuries to Mr. Murphy. He apparently injured himself after stepping down or falling off a piece of construction equipment, and we contend that it would not be foreseeable as a matter of law that someone falling from a piece of construction equipment after an automobile accident could be attributable back to Ms. White. The cases that are cited by the plaintiff in support of this broad notion of proximate cause, we do not believe stand for quite the extent of the proposition presented here. One is Owens, which involved a liability against a paving contractor for how they had set up or tried to control traffic. The primary negligent act was a speeding motorist who hit someone else, and this claim was actually brought against the contractor. We don't believe those facts are pertinent here. We also have Smith, which involved a claim against a tractor trailer who overturned, causing a traffic backup. Then there was another motorist who rear-ended someone that being brought the claim against the tractor trailer who turned over. We again believe that goes farther than the facts that are alleged here. There's also, to the extent there's a claim for negligent infliction of emotional distress that has been raised by Mr. Chad Murphy for seeing an impact to his nephew at the scene. That claim would be barred by the impact rule, which requires a physical contact between the negligent tortfeasor and Mr. Murphy, and then none of the exceptions to that would apply here, and that there was not a direct familial relationship of a parent seeing a child injured. Now, there's been an amendment to the First Amendment complaint that alleges some pecuniary losses and makes other allegations. We haven't briefed that particular issue, given the change in the amendment that's been made, so it may make the argument moot, and I don't know if that's necessarily before the court, but I didn't want to point that to the court's attention.
So you saying that the First Amendment complaint has been amended again?
It's been amended to add particular allegations regarding recklessness, I believe, as to Defendant White, and explicitly laying out claims of pecuniary loss to Mr. Murphy, which I understand are efforts to get around, so to speak, the impact rule. Again, we haven't briefed the impact of those new explicit allegations. So to the extent they're raising a specific negligent infliction of emotional distress claim, I don't know that that issue's been properly placed before the court, at least from our end on challenging that because of the amendment.
Okay.
Turning to the second claim, which is a direct action against Georgia Farm Bureau for a breach of contract. To the extent that plaintiff is making an alleged bad faith claim for refusal to pay plaintiff, and I do believe that they are making that claim because, as I noted in the reference to paragraphs 35 and 39 of the First Amendment complaint, they're seeking fees and expenses, and they're also alleging that the reason for the denial of the claim was motivated by bad faith. That's not improper to pursue that here, because a prerequisite for a claim of bad faith against a UIM carrier is first obtaining a judgment against the tortfeasor, which has not been done. OCGA 33711 provides that the question of bad faith, the amount of the penalty, if any, and the reasonable attorney's fees, if any, shall be determined in a separate action filed by the insured, in this case that will be Mr. Murphy, against the insurer after a judgment has been rendered against the uninsured motorist in the original tort action, which would be Ms. White. Further on that, we have Lewis versus Cherokee Insurance Company, 258 Georgia 839, providing that the plaintiff must obtain a judgment against the uninsured motorist before filing suit against an insurer for the bad faith penalty and attorney's fees. Given that, Your Honor, that we do not yet have a judgment against White, any sort of claim for bad faith directly against Georgia Farm Bureau is improper in this action. Additionally, the claims against Georgia Farm Bureau are improper because the plaintiff is required to obtain a judgment against the tortfeasor before Georgia Farm Bureau has an obligation to pay in the first instant. Without entry of that judgment against White, there's no liability from Georgia Farm Bureau to the plaintiff, and we would not be a proper party to this action. I point the court to Cohen versus Allstate Insurance Company, 277 Georgia Appellate 437, where it provides that the uninsured motorist tort liability must be determined before the UM carrier can be held accountable on its contractual obligation to the insured. The fact that Georgia Farm Bureau has elected at this stage to file an answer in its own name and defend does not change the outcome. And that's Bowles versus Hamrick, 194 Georgia Appellate 595, providing that filing of an answer by the uninsured motorist carrier in its own name does not by itself eliminate the requirement that a judgment first be obtained against the uninsured motorist as a condition precedent to a claim under the policy against the insurer. I do believe in some of the briefing from plaintiff, he's made reference to language of the policy itself, which would be outside of the pleadings and not appropriate for the court to consider at this stage on our motion. I would also note, getting ahead here in plaintiff's response, that they don't have any actual appellate decisions explicitly addressing and endorsing plaintiff's inclusion of a breach of contract claim against the UIM carrier where no judgment has first been entered against the tortfeasor. From my reading, there's only been some trial court orders, some passing references to what might have happened below, but we're not, I believe, before the Georgia Court of Appeals to address, and certainly a non-binding treatise. So for those reasons, Your Honor, we believe that the breach of contract claim directly against Georgia Farm Bureau is improper. Now, to the extent that the court were to say that a breach of contract claim could be sued against Georgia Farm Bureau directly, which we're not conceding here, such a claim would only be valid to the extent that Georgia Farm Bureau maintains its election to pursue a defense in its own name. Georgia Farm Bureau reserves the right and has the right to withdraw its answer and enter an appearance in the name of the defendant, at which point any such claim, should the court allow it to proceed, would no longer be valid as to Georgia Farm Bureau. Thank you, Your Honor.
All right, give me one moment. So just for the last thing that you said, that if the court found that the breach of contract claim is considered proper, then if Georgia, I just want to make sure I'm clear on what your position is. If the Georgia Farm elects to proceed under the defendant's name, and then that breach of contract claim is no longer valid.
That would be our contention if, while we do not concede that, if the court were to find that, if we did elect to appear in the shoes of the defendant, so to speak, then that breach of contract claim would necessarily go away.
Okay. I just want to make sure I understood that.
Yes,
I've
Your Honor.
had this issue before. I don't remember how that came out. All right, Mr. Hudson, are you ready?
Yes, ma'am. And just before I forget, the last thing that was said, I don't disagree with that. If Farm Bureau was to withdraw their answer and enter a defense on behalf of the defendant, then all of these issues, I suspect, would become moot. But my suspicion is that that's not going to happen, because I don't know if Your Honors had a chance to look at our brief, but we included a link to this accident or incident in our briefing. There's a companion case. This case is about a gentleman named Chad Murphy. And Chad Murphy is the owner of a construction company that was working alongside the road, and his nephew is a gentleman named Cole Murphy. And Cole Murphy is like I said, his nephew, and is also his employee. And Miss White's coming down through the construction zone, and she plows through Barrel and right into Cole Murphy, and it sends him flying through the air. Seeing that, Mr. Chad Murphy gets down off his excavator to go render help and assistance to his nephew. And the assistance was necessary because Miss White, rather than stopping and rendering aid herself, did stop and then took off. Mr. Murphy was literally the first person to his nephew and most likely saved his life. But in the course of performing that rescue, he was injured fairly significantly, to be honest with you. I hope Your Honor will take a look at the video. If you can't get it for some reason, let me know and I can give another copy. But it's as horrific of a video as I've ever seen. And to suggest that it would not be foreseeable for someone to come and seek to rescue a nephew and employee after having witnessed something like that is frankly absurd. Now, the interesting thing about this case is you have not noticed that there is no representative of Ms. White here today. That is because we placed a demand on her liability carrier, and her liability carrier, State Farm, paid the policy limits. We included that limited release in our briefing. I believe it's the final exhibit. We also placed a demand. After that happened, we placed a demand on Farm Bureau, who has insured Mr. Murphy pretty much his entire adult life. And Farm Bureau has denied payment and also denied that there was coverage. So in those scenarios, as Your Honor has probably pointed out, this is the typical sort of course of things. A lawsuit is filed against the at-fault party. The at-fault party is served, and then the UM carrier answers in its own name, which is what has happened here. And the UM carrier has a choice. They can file an answer, or they can not answer, or they can file an answer in their own name. And at this juncture, Farm Bureau made a choice, and they decided to file the answer in their own name, not in the name of Miss White. In doing so, Farm Bureau chose to participate in this case, and as a result, they become a party. They do not have to participate, but they chose to. And as we sit here right now, they are a named party, as they readily admit.
Can
So
I ask
once
a
they-
question? I'm sorry.
Yes,
I
ma'am.
just want to be clear on something. So this is this might seem like a dumb question, but these are some very unique facts. So I want to make sure that I understand what's going on.
Yes, ma'am.
So Farm Bureau is Mr. Chad Murphy's auto
Yes, ma'am.
insurer.
And then Utica, who is on here, is his company's auto insurer. And the way, and you guys can correct me if I'm wrong, the way sort of the flow works is your own auto insurance, because it receives the premium from you directly. They are kind of first in line. So that's why Farm Bureau is the one here today.
Okay.
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 All right.
Yep.
So
You can
once
continue.
Farm Bureau decides to answer in their own name, they become a party just like any other party. They must participate in discovery. They must subject themselves to depositions. They must do all the things that any other party does. And Farm Bureau is not willing to do that. On page 3 of our brief, we kind of explain what the ramifications are. And we're citing to a case, Moss versus Cincinnati Insurance Company. And that case says, with the right to defend, there must become the attendant risk of defeat, which would result in a judgment against the insurance carrier in favor of the insured for the amount the insured would be legally entitled to recover from the tortfeasor. To obtain a judgment against the UM carrier, the plaintiff may consolidate two suits, one against the known or unknown tortfeasor and one against the insurer. And that's what we've done here. And what's typically done is once the insurance company actually enters the case and becomes a party, then the complaint is amended to add a breach of contract claim against the insurance carrier so that that issue can be litigated. Now, you don't have to believe me. I've cited to you an excerpt from Jenkins and Miller, who are the preeminent authorities in Georgia on these issues. And they recommend that all plaintiffs' counsel should amend the complaint to plead the contractual case of action against the UM carrier for uninsured motorist benefits. We're fine. These guys are defense lawyers. They represent insurance companies, and that's what they suggest that should happen. So they also must comply with the Civil Practice Act. I feel compelled to point out the obvious of what's going on in this case, Your Honor, other than the fact that there is no one representing Ms. White in bringing these claims. At issue in this case, because it is a fairly unique set of facts, is whether or not there is coverage under the insurance policy. Now, there's multiple ways to get that issue in front of a court. And what Farm Bureau has chosen to do is present that issue by filing an answer in this case. Now, they did not have to file an answer like we discussed later, but they did. And as a result, whether or not there is coverage under that insurance policy is probably the most important issue to be determined by the court in this case. And as a result, we have to be entitled to depositions, to discovery, and everything around that denial of coverage. They could have decided to file what's called a declaratory judgment action. They chose not to do that. So had they filed a DEC action, all the things that we're seeking to do in this case would have absolutely been allowed in this case. I mean, in the declaratory judgment action. But yet they chose to present the issue of coverage in this underlying case for Your Honor's consideration. Well, before we can determine whether or not the denial of coverage was proper or not, we have to be entitled to litigate that case. We have to be entitled to discovery, and we have to be entitled to depositions of those and the reasons around why they're claiming there's no coverage. As the posture of this case, as we're sitting here right now, is no different than a declaratory judgment action because of the position that Farm Bureau has taken. Again, tomorrow they can dismiss their answer if they want to and not participate in the case. They have chosen to participate in this case. If they want to litigate in this case, they have to be willing to litigate in this case. They don't get to come into court and tell Your Honor or a jury or whoever's listening that there's no coverage without allowing us to do what we need to do to get to the bottom of that denial of coverage. So just briefly, the claims against Farm Bureau, they are not a bad faith claims under the statute. We did allege that the denial was in bad faith because we believe it was. We also sought attorney's fees. We seek attorney's fees in almost every case, but there is a denial of coverage, and there are a multitude of reasons for why there could be attorney's fees recoverable in this case. Handedly, I believe attorney's fees are proper in this case, given this motion to dismiss. I think it's ridiculous that we're dealing with a motion to dismiss right now. We could have sought sanctions on that basis. We chose not to. But there are a variety of reasons why attorney's fees may be awarded in this case, which is why we pled them. But there's been no pleading that there has been a bad faith denial of benefits or anything like that. Mr. Broder is correct. Those issues are reserved for a later case. That's not what's being done here. All we're asserting is a breach of contract claim. There is not a single case in Georgia that says that the method that we have utilized is improper for any reason. In fact, the only things that are out there, we included with our brief, Your Honor, in Exhibits 1 and 2, illustrations of the way other trial courts have dealt with this matter. It's a pretty standard practice. And then we also included the Jenkins and Miller, if Your Honor will refer to Exhibit 5 in our response. Jenkins and Miller sort of breaks down the procedure that we've utilized. And in particular, they identify 3 reasons why a breach of contract claim against the carrier, when they answer in their own name, is not only proper, it's really needed. The first is, well, we'll get beyond that. That's about signaling to Mr. Broder that I might be a good lawyer. But the second is that it can eliminate the potential for a motion to dismiss or even a motion for directed verdict at trial based on a failure to state a claim in a contract upon which relief can be granted. In other words, if we don't have a breach of contract claim and the issue is whether or not there's coverage, they could actually file a motion to dismiss based on that issue. And then the final reason is that a breach of contract issue, and this is important particularly right now, may frame a coverage issue that the plaintiff must pursue to affirmatively establish and define the scope and extent of the available insurance coverage. So the reason to bring the breach of contract case is to allow the exploration of the denial of coverage through depositions and discovery and things like that. That is the point of the breach of contract claim. Now, like I said, there are no cases that say this method is not allowed. In fact, there's just the opposite. We cited to you Moss versus Cincinnati that explains that. And then there's also another case, Asaf versus Cincinnati, 327 Georgia Appeals. I believe it's 475, where a similar, at least in dicta, it's referenced that this was the method that was chosen. Again, like we said, we can't file a claim for recovery of bad faith. That's not what's happened. This is just a claim for the breach of contract. We did reference in our brief that it is interesting that the arguments that are made by Farm Bureau and Mr. Broder are not supported by their policy. We included a provision in the policy that talks about when payment is due in the policy. And we also cited the Chandler case for you. And what that case says is, as soon as the liability carrier pays its money and a limited liability release is entered, then a claim can be made against the carrier. There's no requirement that a judgment be issued before the carrier is obligated to act in good faith and do what it should do for its insured. Instead, it's exactly what's happened here. As soon as the limited liability release has been entered and a proper demand has been put on the carrier, they are obligated to pay that money. Farm Bureau has chosen not to. That's the Chandler case that we cited in our brief. So on this issue, we are entitled to discovery. We would ask Your Honor, we put that in our brief. I have not filed a motion to compel, but we did serve discovery on Farm Bureau with our initial filing. Farm Bureau has not responded. They have filed a response to discovery, but the responses were not verified. No documents were produced. And I have written Mr. Broder on a number of times asking for full discovery, and we haven't gotten it to this point. We also intend to seek depositions of the people that were responsible for this denial of coverage. And we would ask Your Honor preemptively to go ahead and let the parties know that that's going to happen so that we can discover what really this denial of coverage is all about. Without those, like I said, they're bound to comply with this Georgia Civil Practice Act being a party, which means they're bound to participate in discovery like any other party. Now, that's the breach of contract issue. That's the issue that you generally see brought up by carriers. And like I said, the brief kind of talks about everything and the ways that it's done and how other trial courts have handled that issue. And I would ask Your Honor, just like those trial courts, to deny this motion to dismiss, particularly at this juncture, and allow the claim to move forward, and require them to fully comply with their discovery obligations in the case. So, moving away from the breach of contract case by Farm Bureau, the next issue that was raised was a causation claim. And I guess the argument is, because of the nature of the incident and the injuries to Mr. Murphy, that there is not a causal link between the crash itself and the injuries to Mr. Murphy. That one surprised me quite a bit. According to Farm Bureau, if you read their motion, it says plaintiff fails to state a claim for relief as to negligence of the alleged uninsured tortfeasor, which would be Miss White. That was strange to us because, as I said earlier, you don't have Miss White's lawyer raising that issue because her insurance carrier already paid their money and must have believed that there was a causal connection to have done that. You have Mr. Murphy's own insurance carrier saying that there was not a causal connection to the negligence of Miss White. But that is interesting because Farm Bureau has already admitted that plaintiff states a claim against Miss White. So their position is that plaintiff fails to state a claim. That's why they filed this motion. We included, with Your Honor, I believe it's Exhibit 4, Farm Bureau's responses. Now you'll see at the top they called themselves unnamed defendant, but Farm Bureau filed responses to our request for admissions that we did serve on them initially. And in response to number 6, we asked, plaintiff states a claim upon which relief can be granted. And in response to that, Farm Bureau said admitted as to Artisha White only. So in response to their request to admissions, they have admitted that plaintiff states a claim against Miss White. Yet in their motion to dismiss, they say plaintiff fails to state a claim as to Miss White. We were confused by that. We went ahead and briefed the entire issue, but that caught us off guard. Nonetheless, that admission should warrant denial of that portion of the motion in and of itself. And I'm not sure if there was an error or a mix-up or what there was, but we spent quite a bit of time briefing an issue that seems to have already been admitted by Farm Bureau. Moving beyond their admission about failing to state a claim, the motion itself seems to suggest that the negligence of whether there's negligence of Miss White is causally connected. Well, not only did Miss White, in her response to her request for admissions, admit negligence, right? She admits she was negligent in causing the collision, which is the incident upon which causation is connected. Farm Bureau did also. So not only did they admit that we stated a claim, they have also admitted that Miss White was negligent in connection with this crash. And they just about have to. If Your Honor will take a look at the video, there's no way to say anything other than Miss White was at least negligent, and honestly quite a bit above that, given the fact that she ran through a construction zone and then left the scene of the crash. The negligence of Miss White has been admitted by both parties. And we gave you in the exhibits to our response, we gave you both the admissions that were filed by Farm Bureau and by Miss White herself. Moving beyond their own admissions, whether or not there is a causal connection between negligence and ultimately an injury, Your Honor, that's for a jury to decide. It's certainly not for a court to decide on a motion to dismiss. As Your Honor well knows, all the allegations of our complaint at this juncture, not only our amended complaint, our first complaint, our amended complaint, and our second amended complaint, all of those must be taken as true. And if you take those as true, and causation and negligence and all that stuff is pled, there's no basis to issue a motion to dismiss at this juncture. You can set aside the admissions up to this point. You have to take, the court has to take our allegations as being true. And at this juncture, there's no way to dismiss the complaint if we accept the allegations as being true. Causation beyond that is a jury issue. And we haven't even been allowed to conduct any discovery on causation at this point. There is something in Georgia called the rescue doctrine, which this case kind of falls squarely under. We've cited, Your Honor, we provided in our materials, I believe it's Exhibit 5. We've given Your Honor another excerpt from Jenkins and Miller that kind of describes the parameters around the rescue doctrine. That's what we have pled. Just reading from the brief, Your Honor, on page 6, it says, when the defendant's negligent acts or omissions have created a condition or situation which involves imminent and urgent peril to life and property, in such instances, those negligent acts or omissions are also negligent in relationship to all others who, in the exercise of ordinary care for their own safety, attempt to rescue the endangered life or property by reasonably appropriate means. And again, we've cited a number of cases that support that the rescue doctrine is alive and well. And basically what the rescue doctrine says is if someone acts negligently and creates a situation where life is in danger, if someone's trying to help them out and they get injured in that, then there is a right to recover against the original tortfeasor.
I haven't heard it since law school, but yeah, I do recall.
That's right. And we've cited a number of cases to not only support the rescue doctrine, but I believe what the main thrust of the argument of Farm Bureau is that the injury to Mr. Murphy was not foreseeable. Well, that too is also reserved for a jury determination. And we cited a couple what we believe are similar cases that say that issue not only goes to a jury, that if there is even a superseding cause, that all of that are issues that to be determined by a jury, not by a court, and absolutely not by a court on a motion to dismiss at this point. The emotional distress claim, I hadn't really understood where that came from. It did kind of come from out left field. It's a claim that we always plead. I don't believe the basis of the claim, and this might change Farm Bureau's position, I don't believe the basis of the claim is going to be that our client was injured because he had to witness his nephew. I believe the basis of the claim will be he suffered emotional stress as a result of his injuries. So I don't know if that changes the position or not, but nonetheless, there are exceptions. The reason that Farm Bureau brought it up is because they contended there was not an impact to Mr. Murphy. If you read the cases, it doesn't seem like there has to be directly an impact to him for there to be a recovery for emotional distress. Nonetheless, there are exceptions to that rule when there is a pecuniary loss, which in this case there would be given the medical expenses. And there's also an exception when the tortfeasor acts willful and wanton and reckless and stuff like that, which in this case, it was alleged in the original complaint that Ms. White had acted that way. Just for clarity, we went ahead and amended the complaint again to kind of nip that in the bud. And we briefed the issue in response Farm Bureau had the opportunity to brief the issue and they chose not to. So I believe the initial response renders that position wrong, but nonetheless, it becomes moot after we've amended our complaint. So where do we go from here? I don't believe, obviously, as you can tell, there's any basis to grant a motion to dismiss either of these at this juncture. And we need to be able to move the case forward. I've been asking Mr. Broder to participate with me since the beginning of the case, and I haven't been able to get the discovery responses that we're entitled to. And I also have been asking, if you look at, I believe it's Exhibit 7, I included some of the communications back and forth where we're not only trying to get our discovery, we're trying to get deposition scheduled. And I fully anticipate, Your Honor, given the issue as between us and Farm Bureau is whether or not there is coverage under the policy. I fully expect at some point, if these motions are denied, that Your Honor will be hearing a motion for summary judgment as to coverage under the policy. And it would be patently unfair for us to be unable to respond to that motion because we're not allowed to have the discovery that we're entitled to. So again, I'd ask that the court deny the motions, and then, get us on the way of moving the case along so that we can push the case like we need to. Thank you, Your Honor.
Thank you, Mr. Hudson. Mr. Broder, you get closing on your motion.
Yes, Your Honor. I would note at the outset that we are at a motion to dismiss stage. So the determination for the court is going to be based on the four corners of the pleadings and the law as it applies. So consideration of video, policy language, prior tenders, and what State Farm has done would not be something for the court to consider in reaching its decision. Second, there, I think, is acknowledged by opposing counsel the mechanism of bringing a breach of contract claim against the UIM carrier directly is only a matter of dicta in the cases that have been brought forward. And kind of along those same lines, we would object to what seems to be essentially requests for a motion to compel discovery regarding Georgia Farm Bureau and providing depositions for a couple of reasons. First, obviously, the outcome of this motion to dismiss would determine whether such discovery was necessary. Second, I think the parties have given an opportunity, depending on the outcome of this motion, would have an opportunity to get that sorted out without needing the court's intervention at this point. And third, as it relates to the breach of contract, I think underlying this and some of the discovery that's requested is that they want to seek a decision as to the reason for the denial, which is perhaps discovery seeking whether that determination was made in good faith or bad faith, which, while disclaiming that that's what they're bringing a claim for, one suspects the discovery they just requested from the court is necessarily going to tread in those waters, which I imagine we're probably going to possibly have to have a conversation with the court again about. So, the reason why perhaps we don't keep breach of contract claims in is to let the case be cleanly tried on the issue of the fault of the tortfeasor, and to the extent that the facts fit within particular coverage or not, that's something that can be addressed to the court at that time. And finally, regarding the issue of the negligence of White, there's no dispute about that. The question is whether or not the negligence of White that led to the injury to Mr. Chad Murphy's nephew was the proximate cause of Mr. Chad Murphy's injuries. Thank you, Your Honor.
All right. All right, thank you all. Miss Luong, was your name formerly Utley?
No, ma'am. Miss Utley is my associate.
Okay, I just wanted to make sure.
Yeah.
Sometimes we have attorneys' names under the wrong person.
Mhm.
So I just wanted to make sure that you were under the right party here. So
Yeah,
did you have anything that you wanted to state, or are you just observing?
just observing, Your Honor.
All right, very well. All right, we'll take a look at this, try to get you all in order very soon on this matter.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Ms. Maynard did put the instructions in about the takedown. I'll leave
Okay.
that up for a moment to let you all take a look at that. Thank you.
Thank you. I've got a copy of it. May we be excused, Your Honor? Suppose so.
Yes.
Thank you so much. Good to see you, Shane. We'll be in touch.
Yeah, good to see you guys. And hey, help me. Where do I find? Oh, in the chat. Got it.
Yes.
Okay. Okay. Thank you guys so much. Take care.
I hope your first Zoom hearing went too bad, Mr. Hudson.
No, ma'am, it was fine.
Okay.
It was much better than requiring me to drive up there. Thank you so much.
Yeah, I this is the only time I really do Zoom is for civil actions that are represented on both sides.
Yes,
Everybody
ma'am.
else has to come to the courtroom. I don't do Zoom for that. So
Well, it's good seeing everybody. I appreciate y'all.
take care. Bye-bye.
Bye-bye.
Ms. Maynard, you good?
Yes, Your Honor. Thank you.
All right. I'll see you tomorrow.
All right, see you then. Oh, so we don't need to do the second one here for Capital One?
No, that was dismissed.
Oh, perfect. Okay. Have a
Okay.
great day.
All right. Bye-bye.